2021 case for a motion to terminate community control that was filed back on January 30th of 2024. On February 7th of 2024, the defendant waived his probable cause hearing. State's understanding today is here to waive his final hearing and proceed to sentencing. There are 4 violations within the motion in the 2024 case. We are here today for a sentencing. On June 14th of 2024, the defendant entered a plea of no contest to the indictment, count 1 being failure to comply with an order or signal of a police officer, felony of the 3rd degree, and count 2 being obstructing official business, a felony of the 5th degree. At that time, an updated pre-sentence report was ordered. It's the state's understanding that that has been completed and provided to the court, and that all parties are prepared to go to sentencing in both cases.
Did we address the PV final at the time of the plea?
We did not, Your Honor. We
Okay.
only dealt with the new case
Okay.
when he came in on the plea.
So in 21-209, the violations, first violation, indictment of 2 counts of drug possession. You understand that? In Cuyahoga County, you understand that charge?
Yes, sir.
Second, the second was the new charge, is failure to comply. You understand that charge?
Yes, sir.
Third, fail to report contact to your probation officer with the Willowa Police Department from the January incident. Do you understand that charge?
Yes, sir.
And then you failed to report to the contact to the Cuyahoga County Sheriff's Department on September 21. You understand that charge? Your contact with Cuyahoga on September 21 of 23. You understand that charge?
Yes, sir.
All right, Ms. Hibbert, how does he want to go forward on the probation violation?
Your Honor, he would admit to the probation violations.
Is that what you want to do, Mr. Alston?
Yes, sir.
All right, what's your plea to those violations?
Guilty.
All right, I'll accept your guilty plea and find you guilty. All right, Ms. Hibbert, as to sentencing.
Thank you, Your Honor. Your Honor, with regard to Mr. Alston's new case, there are a few different things that I'd like to highlight for the court. First, Mr. Alston did turn himself in on that case. He took the initiative to go to the police department, turn himself in, knowing that he would be incarcerated at that time, knowing that he was on probation to you, and he was prepared to face the consequences. He knew that they were coming. Although the facts of the failure to comply are somewhat egregious in some regards, nobody was harmed. There were no property was damaged. And Mr. Alston, he will tell you himself, he was scared that evening. He thought, the reason that he fled was he thought that he had worked it out such that he didn't have a warrant, and that, so he genuinely believed he didn't have a warrant. And when the officers were trying to tell him, you have a warrant, things deteriorated, he panicked, and he fled. He had, in fact, contacted Cuyahoga County to get his arraignment date changed. He thought that that removed the warrant. It did not. It, in fact, just gave him a new arraignment date. So that was his mindset at the time of that traffic stop. Mr. Alston does accept responsibility, though. He entered a no contest plea, Your Honor, but that was to preserve some of his appellate rights. He does accept responsibility. He knows what he did was wrong. He hasn't tried to dispute it with me in any of the conversations that we've had. And as I mentioned, he went and turned himself in. Mr. Alston, one of his probation violations I'd also like to address is the case that he picked up in Cuyahoga County for which he had the warrant for the arraignment. That case involved a very, very small amount of drugs that were in the back seat of the car that he was driving. He did not even know that they were there. He, again, though, accepts responsibility for having been in a car with drugs in that case, and he is going to go handle that after this is over with. He has that coming as well. So Mr. Alston has a lot of problems as he sits before you today. But one thing I do want you to know about Mr. Alston and about his acceptance of responsibility is that in my conversations with him in the jail, this period of time that he's been sitting in the jail, I can see that he's had time to reflect on what has happened here. He was trying to get on the right track. I know it may not seem like it, but he was very, very involved in his young daughter's life, and it has been extremely hard for him having to be in jail now this whole time, knowing that he had made so much progress with her and with his level of care for her and his involvement with her, and then to be suddenly taken from her due to his own actions. He feels horrible, and I have seen true remorse. I've seen him sit in the holding cell and cry. So I know that he is genuinely remorseful. Mr. Alston, so again, he is accepting responsibility for this. He is trying really hard. It is not easy when you have the record that he has, and that is attributable to the bad choices that he's made, but he really has tried hard. And I'm asking that you consider that he has had this lengthy period which he sat in the Lake County Jail. He has truly reflected. I'm asking that you give him an opportunity to try to do the right thing with you, to give him a community control sanction with very strict terms, and just give him one last chance to try to pick back up on the progress that he had been making prior to this unfortunate incident, for which he is accepting responsibility for, despite that no contest plea. With regard to the license suspension, Your Honor, Mr. Alston does have a previous conviction for failure to comply, which the state has marked as State's Exhibit 1, and they will be submitting. So we don't dispute that there is a previous failure to comply conviction. However, the failure to comply statute, as it was brought to our attention at Mr. Alston's initial plea hearing, requires that there be a mandatory lifetime driver's license suspension. And Your Honor, we would have, should you impose that driver's license suspension, we would object to the imposition of that driver's license suspension on the basis that it really affects Mr. Alston's due process rights. He had no notice that could be coming in his previous failure to comply, which I have the transcript from that previous conviction. In addition to the state having the journal entry, which is State's Exhibit 1, I have the transcript from that hearing, which is Defendant's Exhibit A. Mr. Alston was never advised at that time of a driver's license suspension. So his license wasn't suspended for his first failure to comply. And now here he sits before you, having pled no contest to another failure to comply, and he's facing a mandatory lifetime driver's suspension. Your Honor, you know from your role as a jurist that there are so many defendants that sit in front of you, and it's so difficult to accomplish anything without a driver's license. It just makes everything 10 times harder. And Your Honor, we would also be objecting on the basis that it's cruel and unusual punishment. And not just necessarily in Mr. Alston's case, and this is more of an appellate argument, but for people who live in rural areas without a driver's license for the rest of their life with no privileges either. That is cruel and unusual punishment in this day and age. So we would be objecting to any imposition of a...
Well, I mean, there's no right to a driver's license, is there?
No,
Okay.
it's a privilege. It's a privilege. But we would be objecting to any imposition of a lifetime driver's license suspension without privileges, even though it is required by the failure to comply statute. Thank you, Your Honor.
Mr. Alston, what do you want to tell me?
I just want to apologize to the courts. You know, I really was trying to do everything I needed to do when you gave me a chance on probation. I was able to remain clean after my first incident. I'm just trying to be a man, get back to my child, do what I need to do, continue to show you that I could be an upstanding citizen, and just prove to the whole Lake County that I can do what that needs to be done. And that's why I turned myself in to deal with the new charges and everything, and the old charges.
All right, thank you. Ms. Cutts?
Thank you, Your Honor. Your Honor, in the 2021 case, defendant has convictions for having weapons while under disability, felony of the 3rd degree, and aggravated possession of drugs, a felony of the 3rd degree. Those charges stemmed from activity within a bar that he was in. He had a loaded loaded firearm within the bar, and then he was also found to have drugs as well. What makes that one, besides being in front of your honor, relevant as well is that when officers located him, he ran from them. He was not in a vehicle, but he was on foot. He shouldered officers, 2 fell to the ground. He was on bond at that time. He had overbulk amount of mushrooms, psilocybin, psilocin, as well as the loaded firearm in the crowded bar. There was a presumption for prison on the aggravated possession of drugs. The court overruled that presumption at that time and gave him a chance on community control. He was given community control with a lot of drug treatment, even though at that point he didn't think he needed it. He was 50-50 on whether he needed it or not. Following that sentencing, which was August 5th of 2021, he had various conditions, JTP, NeoCap, returned to Murtis Taylor. He did have a probation violation in 2023, and that violation was of a very serious matter. First he was failing to report to probation. He tested positive for marijuana and methamphetamines, and he brought in fake urine. So he was trying to deceive, not have contact, to keep his positive drug charges out of this court's knowledge. Then we have this incident in 2024, where we don't dispute that he turned himself in, but they knew who he was. They had his driver's license in hand. It's not that he wasn't going to have to deal with these consequences. For this incident, the failure to comply as well as the obstructing official business, defendant was stopped, tint issues on his vehicle, which he had had before, as well as he had a warrant. Whether he believed he had the warrant or not, the police were telling him they would call to verify it, but they need to get out of the car. Before he even took off, there was obstructing official business. The officers tried to have him open the door and come out. He put his window up. The door was played with back and forth, him pulling it closed. He would not cooperate with law enforcement. And then he took off at a high speed. He was going up to 100 miles per hour at times. He was going through traffic lights, through stop signs. He was moving into other lanes of traffic. He went through residential neighborhoods. The police were not able to catch him. We are not aware of any damage done to property or people, but the risk that was created was substantial. He was through residential. He was going fast. It was in the nighttime. However, there were other cars on the roads. So this incident in and of itself is very serious. He would not comply with officers. He has had a prior failure to comply, a felony 3. He knows he cannot take off from the police, but he did it anyway. He also has a history of criminal convictions and adjudications, going back for juvenile adjudications. In 2005, he has a jaywalking, but he has an assault. He also has some curfew and unrulies from 2007. His adult history began in 2008 with a carrying concealed weapons conviction. That was a firearm. In 2010, he has a misconduct on public transportation and disorderly conduct. In 2014 is his first felony conviction. First he had a drug abuse, but then he also had a possession of drugs felony the 5th degree, which was a reduction. He did get intervention in lieu of conviction, but he violated and was put onto probation. He had probation violations of testing positive. That same year in 2014, he had multiple possession of marijuana as well as another possession of drugs. In 2016, he had more possession of marijuana drug paraphernalia. He had 2 failure to appear, some contempt charge. He also had another possession of drugs, another contempt of court, and possession of marijuana. In 2007 is that prior failure to comply felony of the 3rd degree conviction in Cuyahoga County. There were various issues in that case. He also had improper handling of firearms in a motor vehicle, a felony of the 4th degree, and a possession of drugs felony of 5th degree in 2017. In 2021, he had a carrying concealed weapons. The conviction is to a misdemeanor. It was reduced. That was also a firearm. And then he has the case that he's currently on probation with this court, the having weapons while under disability, F3, and aggravated possession of drugs, F3. Again, he had a probation violation of a serious nature in that and is pending, obviously, the probation violation today, not just for the new offense, but for not informing probation of his Cuyahoga County offense, or his contact with the police, his contact in both the Lake County and the Cuyahoga. He was not keeping his probation officer aware of what was going on. He does have pending warrants. Part of that has to do with the Cuyahoga County case that is pending. Those are two F5 possession cases, but again, psilocin, so mushrooms, and methamphetamine, that is pending, as well as a Shaker Heights Municipal Court failure to appear. So he was on probation when he committed this new offense. He hasn't responded favorably in the past, specifically to the 2021 case, as well as his past in general with probation violations and failures to appear. So he has run from the police before, one in a failure to comply, one in the 2021 case where he ran from them on foot. He has 4 firearm convictions. That includes the 2021 case. He has had treatment opportunities in the past, IOPs. He's had 3 attempts. 2 were unsuccessful. The 2019 was successful. And then in the 2021 case, the court also gave jail treatment program, NeoCap, and Myrtis Taylor. He did test positive as a probation violation. It's the state's view that the defendant is not amenable to community control. He has been given opportunities, even when there was a presumption for prison, that was overridden so that he could be placed on probation. Then he violated with serious violations. And now he has a new offense, as well as was not communicating with his probation officer. Based on all of that, we do feel that prison is consistent and appropriate in this case. In the new case, the 2024 case, he has 190 days credit. There's a mandatory driver's license suspension for life. He was advised in this court that it was mandatory life, and he still went forward with his no contest plea. He was advised here, as well as in a situation where it is your first offense, it's still a mandatory driver's license suspension from 3 years to life. So you can still get the mandatory life without privileges on your first one. It is just required in your second one. So we are asking that the court follow that requirement that is specifically stated in the statute for failure to comply. We would also ask for prison in the probation violation case, the 2021 case. He has had opportunities with a violation previously, and he has not followed through on that aspect. He has 200 days credit that only go to that case, depending on how the court looks at it. The 190 days he was also in on the probation violation, but the 210 are specific to the 2021 case. And since prison, the state is asking for prison, prison must be consecutive to all counts in all cases if the court is inclined to do that. So we are asking for consecutive sentences. And there's no merger. We would ask to enter State's Exhibit 1, which is the certified conviction of the prior failure to comply out of Cuyahoga County.
Okay.
Should I bring that up now? It was provided to defense counsel in discovery sometime back.
All right, and Ms. Hibbard, you wanted to submit?
Yes, Your Honor, Defendant's Exhibit A. Yeah, Coach.
Yep. And is your argument that he wasn't informed that a second would lead to a mandatory lifetime suspension?
Yes, and that his previous plea was not made knowingly, intelligently, and voluntarily based on the fact that he wasn't advised at all of a potential driver's license suspension whatsoever with regard to the charge of failure to comply. And just for the record, in that case, and I believe it's noted in the transcripts, that case, he was on a dirt bike. It was not a car. Just to expand on that slightly, it's our position that failure to comply is therefore an enhanceable offense, and he wasn't advised, again, whatsoever, of a driver's license suspension in that failure to comply.
So he
Conviction.
wasn't suspended in that case?
No, Your Honor.
Ms. Cutts, anything you want to say about that?
Your Honor, we were just handed the transcript this morning, so I've not been able to review that in any way.
Well,
The law is very clear that on your second one, that it's a mandatory life. And as I stated before, even if it was your first one, you can still get mandatory life on your first violation. He was notified here. I can't speak to Cuyahoga County. That's something that defense would like to take to the Court of Appeals. We've received no case law that indicates that that is accurate. We are following the statute, which indicates that a mandatory lifetime suspension is required for your second F3 failure to comply. He was notified in this court. He chose to still go forward with a plea.
okay. All right, I've reviewed the updated pre-sentence report. Consider what counsel has said, what Mr. Alston has said, the exhibits submitted by the state and by his Exhibit 1 and defendant's Exhibit A. And I have considered all the applicable statutes, 292911, 292912, and 292913. Now, Mr. Alston, you were here on August 5th of 21 after a plea to having weapons under disability, a felony 3, and aggravated possession of drugs, a felony 3, which had a presumption of prison. And I determined at that time that you overcame that presumption. I placed you on community control for 5 years with certain conditions. And there was a violation that was concluded on July 19th of 23 in which I kept you on community control. And then this violation for not only picking up the new case in Wickliffe, but not reporting things to your probation officer. You've got a felony possession of drugs in Portage County in January 14. You've got this failure to comply in Cuyahoga County in June of 16. Improper handling of firearms in a motor vehicle and drug possession in Cuyahoga in 17. A carrying concealed weapon that apparently was reduced from a felony to misdemeanor in January 21 in Portage. And then various misdemeanor drug convictions. So you're well aware of the system. You're well aware of what goes along with felony probation that you had many opportunities for. And you just haven't complied. And when you were here in August of 21, I gave you a chance I apparently shouldn't have given you with that presumption for prison case, and then I kept you on probation the second time. Now in this case, in the new case, halfway between Lakeland Boulevard and Euclid Avenue, you're stopped. And you gave the officer your driver's license. You were told about the warrant. Wouldn't get out of the vehicle, rolled up the window after shutting the door. And then you take off. You go up 305 to Euclid Avenue. You cross Euclid Avenue down Rush Road going southbound, 25-mile-per-hour residential street with a lot of close houses on small lots, a lot of people between Euclid Avenue and Ridge Road on Rush Road in Wickliffe. At speeds tracked by the police of above 90 miles an hour on Rush Road. There's stop signs between Euclid Avenue and Ridge Road on Rush Road. You ran those. Four-way stop signs. Turn westbound on the Ridge. A lot of intersections between Ridge Road and the entrance to I-90. Went left to center. One lane going each way, you went left to center, ran through red lights, over 100 miles an hour on Ridge. Officer's trying to keep up with you, but is losing ground. Get on 90, and they have to terminate because you're going too fast for them to safely chase you. And you're well aware of the fact that if you get up to a certain speed, that they're not going to chase you, they're going to terminate, which is what they do for the safety of everybody else out there. So clearly, you had no concern for anybody except yourself because you didn't want to get picked up on that warrant. And based on your history with this court and with other courts, after having been given opportunities, plural, by me, you decided to do whatever you wanted to do. So I'm going to find you're not amenable any longer to community control. On the 21 case, on the weapons under disability charge, I'm going to sentence you to 18 months in prison. On the possession of drugs, go ahead.
That's a 2024 case.
The probation violation. There's a weapons under disability
Oh, yes, I
and
apologize.
an aggravated possession of drugs.
I apologize.
Okay, so on the weapons charge, 18 months. On the aggravated possession of drugs charge, 18 months. Those will be concurrent to one another. On the 24, with credit for 100 or 210 days. On the 24 case, on count one, the failure to comply, I'm going to sentence you to 24 months of prison. And on count two, the obstruction, 6 months in prison. Those will be consecutive to one another and consecutive to the 21 case with credit for 190 days. And when you get out, you might be on post-release control for up to 2 years under the parole authority with conditions. If you violate the conditions, the parole authority could return you to prison. Up to 9 months for each violation, up to 1/2 of my sentence. If the violation is a new felony, you could get an additional consecutive prison sentence for the violation, the maximum of which will be the greater of 12 months of the time left under post-release control. Costs are assessed on both cases. I'm going to suspend your license, mandatory lifetime suspension on the 24 case. And Ms. Hibbard, you preserved that issue for appeal. If you are going to appeal, Mr. Alston, you've got 30 days to file your notice of appeal with the 11th District Court of Appeals. Do you intend on representing him on the appeal, Ms. Hibbard?
Your Honor, I would have to discuss it with him. However, I would ask that at this time you find him indigent and appoint appellate counsel. He has been incarcerated. He doesn't have any funds, so I'm not sure that he would be able to ultimately retain me.
All right. So let's do this. Mr. Alston, you can appeal this no contest plea, and you have to do that within 30 days. And You have a right to have a lawyer. If you can't afford one, we'll appoint one to represent you. Ms. Hibbard, if you could either, if you're going to represent him on it, fine, then you can file it. If you're not, then please withdraw, and I will then appoint appellate counsel.
Okay, thank you, Your Honor.
Is there anything else? The bond is released. Anything else, Ms. Cutts?
No, thank you, Your Honor.
Ms. Hibbard?
Yes, just one thing, Your Honor. We would ask that the transcripts from these proceedings, from the 24 case, be prepared at the state's expense.
That'll be granted.